Mr. Hunter, I see that you're here. Mr. Hunter is, Ms. Bogan and Mr. Hunter, are they here, sir?
Judge, they're represented by counsel.
Have the parties had a chance to talk?
Yes, we have such, there's no resolution at this time. Judge, it is my understanding that parties were to exchange documentation at the last hearing. I
I was just trying to get an idea of
Yeah,
where we were.
yeah.
When we were
So,
before we keep on, hold on just 1 second.
okay.
All right, calling case number 23348-137. This is the case of William D. Hunter versus Caprice Bogan and Donnie Hunter at 7800 East Jefferson. Parties, please identify themselves for the record.
Yes, good morning, Your Honor. I would like to carry on behalf of William Hunter, 840039.
Good morning, Your Honor. Yvonne Tarakian, 886598, on behalf of the three defendants who are beside me, would you like them to identify themselves to the record, Judge?
Yes, please.
Caprice Logan.
Donnie Hunter. All right, thank you both. And I see Mr. Hunter in the courtroom as well. Mr. Hunter, can you please state your name, sir?
William.
Thank you, sir. All right, Attorney Woods, Attorney Tarakian, it sounds like you two wanted to say something before we get started. Go ahead.
If I may, Your Honor, on behalf of Mr. Hunter, we produced, when we were before the court on May 26th, the court advised both parties to present any documentation that they had. We have presented a lease in Mr. Hunter's name for this apartment. And I would just note for the record, Your Honor, this is an apartment for the tower. It is an apartment for senior citizens and disabled individuals. Mr. Hunter meets both of those criteria, so that's why he qualified for this apartment. Mr. Hunter took in his niece as a caregiver. They're claiming that they were subleased. But be that as it may, if we assume everything they say to be true, Mr. Hunter has filed asking them to get out of his apartment. He wants his apartment back. That's all we're here about. So it doesn't matter how much money they paid or they're claiming they have a sublease. The litigation here today before it's on the court is for him to take his apartment back. And he's entitled to that. There's a provision in the lease, paragraph 13, that doesn't even allow for a sublease. But again, be that as it may, let's assume what they're claiming to be true. They did not bring a sublease agreement here today to court. They've shown me some PayPal's or Cash App payments that they supposedly made. But it's not even about the money, though. This is a proceeding for eviction out of the premises. He wants his apartment back. He wants them to. They don't have a right to just keep staying there. And I understand why they want to stay there. The rent's only $438. I heard on the news the other day that the average rent across this country is $2,000. So I understand why they want to keep staying, but they can't. And so all we're asking is that Mr. Hunter, as the law, they're basically trespassing at this point. So he just wants his apartment back. We just need, and I kept asking them, what day can they be out? I kept asking that, and apparently they don't want to be out. They want to just keep staying there, but they don't have a right to do that. So we just want a date for them to vacate. Mr. Hunter needs to get in there and clean the place up. It's filthy. It's got to be painted. Carpets now it's got to be replaced. We just want a date for them to be out. We don't want any money. We just want them out.
All right, Attorney Woods, can I ask you?
Yes.
First question. Was there ever a sublease?
No.
Okay. My second question is Mr. Hunter at you now?
Mr. Hunter had to leave. Ms. Bogan moved her boyfriend in, and Mr. Hunter is a disabled senior citizen. The situation became untenable. He was in fear for his safety because of this behavior and the boyfriend coming into this apartment against and without Mr. Hunter's approval. And so he took himself out of the situation. and started asking me. So, like I said, it was supposed to be just Ms. Bowman. Now she's brought her boyfriend with her.
Was there ever any arrangement where, even if there was not a sublease in place, was there ever an understanding? Sounds like I did hear you say that he allowed his niece to stay there, am I correct?
That's correct.
All right, and for allowing her to stay there, was she paying anything?
She may have paid something, Your Honor, but there was never any formal agreement. You pay X amount of dollars. There was never anything that formal between the two. So we're not denying that she possibly paid some monies. And my position is, if they feel that they paid, that Mr. Hunter got some money that he was not entitled to, then there's another court right here in this building, small claims and your civil division. That's where they should be. If they want their money back, sue Mr. Hunter, I'll represent him, see if they're entitled to get money back. But right now, it's our position that they're trespassing in that apartment and they don't have any legal basis to keep staying in that apartment.
I thought I heard you say that she was to act as a caretaker.
And she was, as I said, that did happen. And she brought her boyfriend in there and basically just started living. She was not providing any care to Mr. Hunter. And he just wants him out.
How long was Ms. Bogan there? Or, I'm sorry, when did Ms. Bogan first come to the residence?
Well, they're claiming the first of the year.
No, not.
Hold on. No, one at a time, she's talking, ma'am.
It was my understanding and what I was shown was some payments that purport to go back to the first of the year or sometime last year. Mr. Hunter didn't even take occupancy of this apartment, according to the lease, until late November.
That's November 1st, right.
November 1st, 2022. So anything that she would have paid would have been December and perhaps January 2023 forward. So anything before November, she could not have been paying Mr. Hunter because he didn't have a lease to be there before then, wasn't there before then. So that's why I said to counsel, the court said bring documentation. You're asking me to look at a phone and some Cash App payments that were made that I have no idea what this is. If they're claiming this was paid to Mr. Hunter as some rent or some sublease, then that should have been printed out, produced for this honorable court, and identified as to what it is. I don't know what that is. All I know is they could not have been paying anything before November 2022. Because that's when it started.
Right, in terms of what's, would that be section 13A of the lease that you're referring to? When I reviewed it, that's what I saw for the prohibition of any sublease.
That is correct.
Okay, I just want to make sure we're looking at the same.
So again, Your Honor, just in conclusion, that they don't have a right to just keep staying there. Mr. Hunter wants his apartment back, and they need to get out. If they feel they paid some money that they're entitled to back, this is not the forum. They need to take it in the proper forum, and we'll resolve it there. But now they're trespassing, and Mr. Hunter just wants them out. Doesn't want any money, just wants them out.
Thank you. Attorney Taraki?
Judge. Counsel is correct that rent payments have been accepted. In fact, the move-in date for November 9th, 2022, with the $942.30. Furthermore, plaintiff is actually related to defendants there. Second of all, it is the understanding of the parties that plaintiff actually resides at 1514 and has resided there for at least the past 12 years. So it's interesting, Judge, that there is this discussion about him having this new lease and saying that she's gonna be a caregiver. Also saying that they're not paying rent and that they don't have a right to be there, but this sounds like a family member who was given access. And furthermore, Judge, while I was not present at the first hearing, where I may have been advising another client, it is my understanding that the parties were specifically instructed not to have contact with one another. And according to testimony, or according to statements from my clients, the locks were changed on June 2nd, 2023, which is after the first hearing. The locks have been changed. They do not have a spare key. This is an illegal lockout and a self-help remedy. At this point now, not only have my clients paid rent up to May 1st, which was after the notice to quit was served, entitling them to a park forest defense, they are also entitled to $200 a day since those locks were changed on June 2nd. Judge, I ask that this case be dismissed today.
Okay, is there any proof of these payments?
Yes, Judge. Now, I again was retained on the case today. The entire transaction history is recorded on Cash App, and I have screenshots of payments. I'm not sure how to get those to the court, and I'm at these tenant defense this morning, but I do have those. The security deposit, it's my understanding that was paid in cash, but even so, then the payments do go back to January 1st, which does line up to what plaintiff's counsel stated on the record.
All right, so you show me Cash App, is this going to show money that's going to the landlord or directly to the tenant?
Yes.
Okay, so again, because if these are family members, while a payment may show the money went to a family member, that unless there's something specifically next to it, I can't tell if that's money being exchanged, payment for something, or will I be able to determine from what you have that it is specifically for rent?
Yes, Judge. The payments are actually labeled rent payments. And furthermore, the increments of the payments reflect rent payments plus what would be a late fee of $50. So I can certainly share those with you, Judge. But there is clearly money changing hands. It's also clear that plaintiff, and plaintiff certainly testified to this, there's another residence involved. So this statement about fleeing the apartment, I don't really, it's not defendant's understanding that there was ever any fleeing. And in fact, it's not the understanding that she was ever to be a caretaker. She was going to live there. And as you know, in the city of Detroit, in the summary proceedings, we often
Attorney
see.
Hunter, hold on. I know you know. Just trying to let her speak. You have counsel here. You want to consult your counsel, we can do that. Now, while counsel speaking, please let her speak. Go ahead, Mr. Ray.
And Judge, in summary proceedings, it is not at all uncommon to see oral leases, and under Michigan law, oral leases are still valid. It's not, and since this is what would now be considered a month-to-month tenancy, a month-to-month tenancy, is not subject to the statute of frauds, so they can have an oral lease. Because each month is a new agreement.
So are you alleging that there's an oral sublease?
I do believe that to be true.
So an oral sublease from month to month?
Yes, Judge.
Okay. Let me make sure I understand this. So what you're understanding that it was an oral lease for a month-to-month tenancy, not for a term of so many months.
I do not believe that to be the case, Judge.
All right, so I'm not sure if you said that with clarity as to know the answer, or you're not sure what you have answered.
I don't believe that it was ever meant to be a term. I believe that it's a month-to-month tenancy, and I understand that that would give me the right to terminate it. I'm not suggesting that there was any term. What I am suggesting is that there was acceptance of rent beyond the notice period, and that there's been, that plaintiff illegally took possession before the finality of these proceedings. So with those factors in mind, plaintiff technically has possession because they don't have a working key to the door. And
Okay, you said the locks will change June 2nd?
Yes, Judge.
All right, and when was the last time the rent was paid?
May 1st, 2023.
And that was paid through the end of the month?
Yes. I'm sorry, it was paid
Yeah, I
up.
was gonna say, if that's the case, if it was paid at the beginning of May, wouldn't the end of May be the end of that month to month?
Yes, Judge.
Okay, so if something occurred on the 2nd, he's told to move out, wouldn't that be notice? And then the time for the move out would have come?
The notice was given, I believe that from the file, shows that our first hearing here wasn't until the end of May. The notice period started in April. And they paid rent and then court. So that should have, the case should have been dismissed at the first hearing. When they paid that rent, they expected that the tenancy was to be ongoing, so.
I need to see proof of these payments.
But, how would you like me to get to that proof, Judge, since they are,
Printed. I can't keep an email on file, and we don't usually give out the court's email list, as I'm sure you're aware, we had number of filing issues last year, so we stopped it. I'll still stand by that policy for a number of reasons. So at this point, I've heard a lot from both sides. Obviously, I can't make a decision without being able to see what the parties are presenting. Plaintiff has presented what is clearly a lease with a provision that clearly does say subleases are not allowed. Doesn't mean arrangements can be made.
There is no sublease.
Sir?
Mr. Hunter,
As I recall, at the last hearing, let me step aside from the arguments made by the parties at this point in time. If I recall from the last hearing, there was a request by the parties, I believe, for some access to get some things. Did that occur without a problem?
the lots were changed, so I'm going to say no.
If I may, Your Honor,
Attorney Wolfman?
Mr. Hunter reached out to his niece about his personal belongings. What was discussed specifically was a flat 46-inch flat screen TV. And it's my understanding that she indicated to him that she had thrown it out. Now, when I was in the unit, I did not see that 46-inch flat screen TV. What I saw was this huge 70-inch screen TV, which her boyfriend, Mr. Hunter, indicated was their personal television. So I their personal television.
Television, I thought there was a request. Am I remembering this incorrect? I thought there was something about a reading machine or some type of medical equipment as well.
Mr. Hunter, in one of the bedrooms, they took all of Mr. Hunter's computer, desk, another bed frame, and they shoved it all into one bedroom. Television, everything was shoved into that one bedroom. Mr. Hunter had requested that he be able to get his things out of there. Contacted Ms. Bogus to do that. It's my understanding that he was advised the television was thrown out and there was nothing, basically there was nothing of his there. And in terms of this lock change, there was no lock change. Mr. Hunter asked the building about a key because he didn't have a key. They changed the locks. And the building gave him a key to the place. Now, if that's not a key that they have access, I don't know. Mr. Hunter simply asked for a key to his apartment, and that's what was given by the building.
Let me make sure I understand what you said. The locks were changed on him? and
Yes.
He had to ask the building?
Yes. And the building gave him a key. Now, we don't know if the building themselves changed the locks, if that's the same key. We don't know. Mr. Hunter just asked for a key that he needed a key to his apartment. And that's what he just did.
Judge, may I take some testimony from the client?
Just a moment. So, that adds another wrinkle to this. Normally, when a building may have to change locks, it's not uncommon for larger buildings. Tenant loses a key for fear of security concerns. It is common for a building to change the lock, to charge a fee.
Yeah, and that's exactly what they did. They charged Mr. Hunter, I believe it was $60.
Do you have any feedback to this?
For the kitchen, we give them the key and charge them. No, I don't have it here. I don't have it where I can present it at this point. And Your Honor, may I just bring something to your attention?
Yes.
One of the reasons this has become a big problem, we need to get them out. The building is questioning who they are because they're not seniors, they're not disabled. Who are these people and what are they doing here? And who are these people and what are they doing here? And Mr. Hunter was trying to tell the building, well, you know, she's supposed to be my niece, she's supposed to be my caregiver, yada, yada, yada. But this has become a problem because they can't be living there. They don't qualify to be there. They're not seniors, they're not disabled. And so if they don't get out, Mr. Hunter is in violation of this lease and he can be evicted and there's possible penalties to Mr. Hunter for them staying there. So it's not just, you know, Mr. Hunter being a nasty person wanting to put his poor niece out. The building is starting to question who are these people and what are they doing here? They're not seniors and they're not disabled. They're not supposed to be here.
Judge, be the facts as they may, it's clear this time, Mr. Hunter is very aware that there are people living in his apartment. He is very aware of the identity of the people living in his apartment, and he is very aware that the locks of the building were changed. And he's also aware that he received a new key. I'm certain that he may also be aware that they didn't receive a copy of that key, and therefore he knowingly locked them out of their apartment.
But I'm not sure, based on the allegations that I heard, was that the lock was changed on him, therefore he had to get a new key because he didn't have it. And I don't know what's what. What I would like to see is the timing of when that happened.
Judge, I was going to offer testimony from the clients they're interested in addressing in court. They have provided a lot of clarity and they're doing their best to maintain composure and they're trying to give respect to all the parties to speak. And I believe it would be fair to allow them to speak since Mr. Hunter has and plaintiff's counsel has. And they have
Mr. Hunter
information.
has testified. Mr. Hunter, he may have gestured with it back, and I don't think he's testified. I'll take the testimony, turn it out. I don't know if you want to take testimony, Mr. Hunter, I'm not sure if that's necessary.
I don't think it's necessary, Your Honor. I with all due respect, and of course, this is this honorable court's courtroom, and do as you see fit. I don't think there's any testimony to be had here that can militate against the lease, the provision in the lease that prohibits subleasing, the provisions in the lease that state this premises is for seniors and disabled people. It is subsidized by HUD, and that's what it's for. And they just can't be there occupying the place. I know they want to stay, but for $400, I would love to be able to live somewhere for $400. But they just can't keep staying there.
Continue, sorry.
Right, ma'am, will you raise your right hand? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
I'm spoken for you right now. Mr. Radley.
How do you know, like, when did you move into the subject property?
sorry, November, and I get the date again.
November 9th of what year?
2022.
And was there an arrangement in place? What kind of arrangement was in place for you to be able to even have access to this apartment?
Okay, so I asked him to help me find somewhere to stay because I didn't have nowhere to stay. And he said, okay, he had this apartment that, he was applying for, and he said he was just gonna put me on a list as a caregiver so I could live there, but I gotta pay the rent and I had to pay the security deposit and first my rent to move in. So I paid that, and then every month I didn't pay the rent on time.
What is the monthly rental rate for Plato?
The monthly rental rate is $428, but I pay $435
Why do you pay $435?
because I sent it to Cash App so he can take it off, because it's the ATM.
So you make all of, how many payments have you made to him via Cash App approximately?
5.
How did you make the other payments?
I paid to move in, I paid that in cash, the security deposit, I paid that in cash, December, I paid that in cash. January through May, I paid Cash App.
What were the late fees on rent?
I never had to do a late because I was on time.
Did you pay the rent in full or in partial payments?
I paid it in full.
And you said, do you have more than, you used one Cash App account? Or do you have more than one payment account?
I had one, but they closed it down, so I had to make a new one, which was last month. So last month I had to pay it from a different Cash App because my other one got closed down.
I just want your mental impression here. Why do you believe that this lawsuit is happening?
I'm going to object, calls for speculation,
Judge.
no foundation.
Sustain it, unless you have some incredible basis to tell me why shouldn't you?
Well, Judge, mental impression for tenant will identify what her understanding was for basis of Park Forest, because Park Forest is of the understanding of the parties. So I didn't have her impression.
I'm not sure you need to go about it by asking what she thinks. You might want to ask her her impression of a number of things, that's different. But the question you just asked, now, I'm going to sustain the objection.
What is your impression? What was your impression when you paid May rent? What was your expectation when you paid that?
No foundation. No
I just
foundation.
paid rent. I didn't keep them.
Well, hold on. I need to just remember. I believe the question was, what was her impression when she paid rent?
Yeah, what was her impression about what?
I'm sustaining that, so again, go ahead, Mr. Rowell. Just,
I'm gonna move on.
you phrased it, I think that's up to you.
What was your expectation about your tenancy with the plaintiff when you paid rent in May?
I just paid rent because, like, I've been getting threatened to put out, like, and since I moved in there, like, every month I've been getting harassed about getting threatened to get put out. So I thought it was just a kind of harassment of him saying he's gonna put me out. So that's why I just paid rent.
So let me just tell me if this is what you believe. Are you suggesting that what are you saying that you think his intention is with this lawsuit?
Objection.
I think I already moved on that objection, it's the same question. So, sustain again.
Can you explain about what you mean by harassment?
Like, I get nasty voicemails. He'll come down there and call me like bitches and stuff like that. So
Mr. Hunter,
I've got
Explain yourself, sir.
proof of the messages and recording. I got
Why? You've known him your whole life, correct?
right.
Have you always had this sort of antagonistic relationship?
No,
Do you have anything else that you would like to add to say before?
you wanted to.
Now, when you moved in, how were you given access to get into the building you do
He gave me a key. So, he gave me a key, so that's the key I was using to get in. The downstairs, the apartment building gave us two keys. He gave me one and he gave Mr. Goodwin one. So he had his key, I had my key. I lost my key, he still had his key. But when June 2nd, when they came and changed the locks, I asked them for a key and they said they already gave it to Mr. Hunter. And he had to turn, in order for them to change the locks, he had to give them his old key, which they said he did. So I just still don't have a key.
So, how many times have the locks been changed since you lived there?
This is the first time they did change.
Thank you, no further questions.
No, no, man, you're still here.
Oh,
Ms. Owen, I just want to be clear about something. You indicated that you made a number of payments to Mr. Hunter in cash, correct?
when I first moved in, yes. The security deposit in December when I paid in cash.
As you stand here today, ma'am, please produce to this court receipts of any kind, evidencing those payments.
I mean, that's how I do.
And would you have a receipt
No,
of any kind that you present to this court?
no.
You indicated that when you moved in, the building gave you a key and Mr. Hunter a key, correct? They did not give your boyfriend a key, correct?
Correct.
Okay. And you indicated that you made a number of payments on Cash App, correct?
Correct.
Now, and that those payments were quote unquote for rent. Now, you understood, ma'am, that you were nowhere on this lease agreement, correct? Did you understand that you were not a tenant, you were not a lessee on this agreement?
No, I didn't understand. From my understanding, I was on the lease of
Okay, well, let me ask you, ma'am, did you ever sign,
Yes.
did you ever sign a lease with Mr. Hunter and River Tower apartment?
Yes, he made me come down to his apartment and sign some paperwork, yes.
Ma'am, did you ever sign a lease with River Tower and Mr. Hunter and yourself?
I signed papers that Mr. Hunter did for me to sign for the apartment.
And-
Wait, hold on, Mr. Hunter. Now, sir, you're gonna have to contain yourself. I understand this may be moving. Landlord tenant is always high strung. I get that. But sir, you know better. I know you know better. Please contain yourself.
As you, I'm sorry,
Please, go ahead, attorney.
as you stand here today, Ms. Bowler, do you have a copy of any document that you signed, Mr. Hunter, that you presented to sign for?
No,
As you stand here today, ma'am, do you have, strike that, I'm sorry. You indicated that the agreement was you come in as a caregiver for Mr. Hunter, correct?
that's just how,
Sir, ma'am, is that your formal title supposed to be Mr. Caregiver?
that's what he,
And you would agree with me that Mr. Hunter is suffering from some physical and other impairments, physical impairments, his eyesight, and he has some health issues, correct?
correct.
So it would be reasonable for
Yeah,
him to have a caregiver.
right, I have no, at the
And
end of the day,
excuse me, and as you stand here today, if you tell this honorable court what services, if any, you perform, as you stand here today, it's fair to say you have not provided any services to Mr. Hunter as a caregiver. Isn't that true?
No, that's not true.
That's okay. So have you cooked meals for Mr. Hunter?
Yes, I have.
Where did you cook those meals?
At his apartment.
On Washington Boulevard.
Yes.
At 78, have you cooked any meals for Mr. Hunter?
No, because he doesn't.
Have you driven Mr. Hunter to any doctor appointments?
No, I don't have.
Have you picked up on Mr. Hunter's behalf any prescriptions from any pharmacy?
No.
And just so we're clear, your boyfriend does not have any kind of written agreement with Mr. Hunter to be a caregiver or a tenant in this apartment, does he?
No.
Thank you.
Karen, may I go very brief redirect? You stated earlier that caretaker was a title given to you. What was your expectation moving in as your responsibilities living in the subject property?
So my expectation was, I just asked him to help me find a place to stay. And my expectation was just me living there and paying rent on time.
Why did he say you would be a caregiver?
Because you have to be, a senior citizen to live in that apartment. So he just said he just gonna put on the lease that I'm a caregiver so I can be able to live in the apartment.
And were there any occasions where he asked you to perform caregiving services in that apartment?
No, I just help my uncle out because he's my uncle, he need help, so I don't have a problem helping my uncle out.
You mentioned that you don't have a car, is that correct?
That's correct.
So you wouldn't be able to take him to any doctor's appointments anyway?
Actually, when I first moved in, I had a car, but when I moved there, January, the car got stolen from that parking lot, so I don't have a car, haven't had a car since January.
When you moved in, how long did you expect to live there for?
Your Honor, I have an objection that this is going beyond the scope of cross-examination. But if the counsel is done with that question, that's fine, and she is going beyond the scope of cross-examination.
Judge
I'm
Alden?
not sure, it sounds like you started with an objection and you kind of let it go, that's what it sounded like to me.
I started with an objection.
That's what, okay, so it sounds like you can continue.
That was my last question about that topic. And when did your boyfriend?
He the one who paid the security deposit in the first month, so he had knowledge that he was living. All the payments, he paid everything.
So how did he pay it?
So now we are beyond the scope of cross-examination.
Judge, this is within scope because plaintiff counsel raised the issue of the boyfriend, so I believe this is extremely relevant.
I'm not gonna overrule that.
Because I think you open that door also, I think the question of payment came from, didn't understand where we are, I'm gonna overrule. Go ahead.
How did the boyfriend make payments to plaintiff?
So for the security deposit in the first month rent, he gave it to him in cash. In December, he gave it to him cash. For January through May, he sent the money to me and I paid through Cash App.
When you moved in, who did you tell that your uncle plaintiff was going to be living?
Me and my boyfriend.
Is it your impression that he never knew your boyfriend was going to live?
No, that's not my impression.
I'm gonna object, Chair.
I'm gonna sustain that one.
Were you hiding your boyfriend from living there?
No, because before I even moved into the apartment, I was living, me and my boyfriend was living with Mr. Hunter.
How long is your boyfriend?
I don't know, we stayed with him before we even moved into the apartment, so I don't know how long, probably like a year.
All right, well, I have no further questions for you.
Ms. Bogan, you said you signed a sublease agreement, or you signed some type of lease agreement?
I signed something that said I was a caregiver.
Okay, I thought you said you signed a lease.
She asked me, did I sign anything with River Tower and Mr. Hunter, and I said, yes, the papers that he brought to me, that he had me sign at his apartment, is what I signed.
I could have sworn I heard her ask you if you signed a lease with the apartment complex. That's what I thought I heard. If what you're telling me is what you signed was something that said you were a caregiver, I just want to make sure I understand. So was it something stating that you were a caregiver, or was there something showing that there was a term of time that you were going to be able to stay there?
It was something about caregiving.
All right, so when you said that there was a sublease, is there any type of written sublease?
No,
And it's your testimony that your boyfriend paid Mr. Hunter in cash first month's rent and the security deposit?
correct.
Okay, were you there when he did that?
Correct.
So that I'm clear, you said you lived with Mr. Hunter prior to moving into this residence. Where was it that you lived with him?
1514 Washington Boulevard. His apartment.
So I'm curious, can you tell me why, if the first month's rent was paid in cash, why did you go to cash then?
Cause I didn't have a car to go down there and pay him in cash, so I just took the cash
Go down where?
to his apartment. I usually would go to his apartment and pay him the money for the rent.
Weren't you two staying at the apartment?
At his apartment, yes, but when we moved in, I paid him with cash. When we moved into 7800, I paid cash. And I had to, my car got took in January, so that's when I had to start making payments through cash in January, because I didn't have a vehicle to get to him to pay cash.
I thought I heard you mention the name of a Mr. Williams. Who's that? Oh, I'm sorry, I would have thought you said Mr. Hunter. I just want to make sure there was the Mr. Williams or Mr. And these voicemails that you talked about, when did those begin?
They began.
You don't have to give me the exact date.
Uh,
Was that
They've
in
been since-
2022?
They've been since January, since I lost my car.
Ms. Bolton, does your boyfriend have a car?
Nope. That was his car that got took. It got stolen out of the parking lot of the 7800 apartment.
So let me ask you this one. So you signed paper that you said would list you as a caretaker for Mr. Hunter. So you would be allowed to stay there. And you said the understanding is that your boyfriend would be moving in with you?
I'm sorry?
And you said that your boyfriend, the intent was that your understanding was that your boyfriend was gonna move in with you as well?
Correct.
Okay, was there anything to say that he was gonna be a caretaker?
No, he asked him to cook for him.
So wait, Ms. Bowman, didn't you say that, you were doing some of the cooking?
No, I was caregiving. I was like cleaning up for him. Like I would go to his apartment and clean up for him and give him his like insulin or whatever, but no, he was the cook. He cooked better than me, so he was just cooking.
I thought you said that you were doing some
No. Cleaning, and you know, remember.
So cleaning, now, if my understanding is correct, last hearing, and now this hearing, it sounds like this is a two-bedroom unit,
Correct.
so everyone is it, let me be clear. So when you moved in November, where was Mr. Hunter?
He was at his apartment.
So you're saying he was never there?
He never was there, no.
So the last hearing that we had, there was a lot of going back about his possession.
Right, he got a couch, he brought tables, he brought bed, all that is in his room, where he had the guy come bring, all that's still there. It's all still there, he had to make it seem like he was living there, because only seniors supposed to live there, which I didn't have no problem with. His stuff is still there, everything's still there. Nothing broke, nothing damaged, everything's still there. And I don't have a problem with him getting stuff, I never, ever had a problem with him.
So what happened with the television?
It broke.
That was why you were there, right?
Huh?
That was why you were there, right?
There, where,
You were at the apartment while the television broke, because
Right.
last time we were here,
right,
I thought I heard you say the television was broke. Now you just told me that you, well, and then you told me the last unit was thrown out. I didn't realize that it was broke until just now. So if he's not there. How long, you said you lived with Mr. Hunter for how long before you moved into this place on Jefferson?
August 2022.
I thought, that's just a couple months. I thought you said you were staying with him for about a year or so.
No, I've been in 700 almost a year, but I stayed with him like 3 months before moving in. The whole reason of me staying with him is so that he could help me find a place, another place to stay.
I have any questions, council, I don't know if you need to.
Just want to clarify a couple of points. Earlier you said that Peter has known your boyfriend for about a year, correct?
Right.
Okay. And earlier you were asked, had you ever cooked any meals for Mr. Hunter? And you said, yes. Did you do it regularly or were you saying, yes, I've done it?
Like when he called in.
Can you please I will rephrase. Can you please clarify what you meant by that?
Okay. When he called and say, okay, when we was living there, I did the cleaning and give him his medicine. My boyfriend did the cooking for me because he liked his cooking better. That's not mistake.
Okay, thank you. And I have nothing further, Judge. I would like to call as an additional witness in that.
No, you're under no check. We've heard testimony that any agreement was between Ms. Hogan and Mr. Hunter. This gentleman has, based on the testimony that you heard from Ms. Hogan, he has no standing whatsoever, so I don't know why he didn't give testimony in this case.
Well, he is named as a defendant, that's
Okay.
one. The other is, I thought I heard that there was also an understanding of who's there. Now, I'm not sure that's true, but at this point, your testimony is rare.
I'm gonna object, Your Honor, as you can see.
I mean, we're not necessarily into trial. We started this issue, to get some clarity on where we were in terms of standing. You made a motion to dismiss. Now, I was looking at a couple of bases. You named a number of things. You don't have any documents to back it up. I haven't seen anything yet. I think I was being kind of generous to take the testimony. I don't know you're gonna get to call the plaintiff. I'm not gonna go that. I have a number of questions based on all the stuff that I've heard that I'd like both parties to submit documents to have. Plaintiff has come with at least their lease. I haven't seen anything else. I'd like to see some subsequent paperwork regarding the lockout portion, where you raised that issue. But as far as these other things, I haven't seen anything. So testimony is about all that you are going for yet at this point. But again, I'll take that. I'm not knocking your case, but I'm saying I don't think you can pull the plaintiff, based on your allegations. Why don't you bring your witness that you have testimony for now?
I don't think we have any. Defense is looking further.
I do have a follow-up question. Ms. Bowles, can you come back? Ms. Bowles, when did Mr. Hunter move his possessions into the place?
It was like, it'd be like, it happened after January, where the couch and stuff was there when we all moved in. When we first moved in, he got the couches that's in his room. That was when we first moved in. The bed frames, the tables and stuff, that was brought like throughout the year, in different days.
Okay, so Ms. Bowles, if I'm hearing you correctly, there was stuff moved in, and it sounds like, if I'm hearing you correctly, you're saying he was never there, he stayed at another residence. But from what I also heard, it sounds like his items were in one room, and then you had the rest of the place to yourself and your boyfriend.
Correct.
He wasn't staying.
No.
I don't have any further questions. All right, what I'm gonna do is give the parties a little bit of time. Tell me how much you need. I'd like to see the paper that the party has. Please, what I'd like to see is people consult with, building management, to see them, I'm sure they probably have something regarding that change of the last. Clearly, that's not the issue on whether or not it occurred. We all know it did. How it occurred and when is the question I have. So people provide that, would be great. Attorney Tarrant, I'd like to print out some of those payments that we made, maybe this show, their indications of what they're for and acceptance what have you. I'd like to see that as well. How long do the parties need?
I'm asking for a very short time. As I indicated, there's a concern about the state of the apartment.
Oh, we weren't gonna go a long time, I can tell you that.
Yeah, and there's a concern that Mr. Hunter is under scrutiny by the tower. So very short, because but it will only take us a day or so to get documentation that you have asked for. I don't know about. And that, because you did tell them to have that available at last year.
Attorney Tarrant, and how long do you think you need?
For you every Tuesday and Friday. How long is your underneath?
As I put that in, and how much there is. If you send a page, all you need is a day. But if you send, several other things, I don't know how much you're gonna have to look at.
Judge, so to clarify, just for purposes of the order, you are requesting that defendant use documentation of payments made? Is that all you're requesting?
Payments made, and I'll go as far as where I was before. Any proof that you have of this understanding that there was a lease agreement and any payments that were made to confirm it, yes. So I think it's a little bit more expansive than just payment. What I heard today is this sounds like a multi tenancy, but nothing written down about it. You got any paperwork? If you happen to find something that was signed by the parties regarding caretaker, what have you, you can add that as well. Any understanding of this arrangement, the care that's to be given, who's gonna cook, drive, provide medicine, cleaning, anything like that. If there's something like that, provide that as well.
Well, I'm willing to adjourn, but very briefly then. You
Tell you what.
can even do 1 week.
Let's see what we have for next week.
All right, just because of scheduling, our schedule, as we're making notes, we have made the transition from virtual to in person. It's no surprise, we have a lot of hearings pressed for the next couple of months. With that in mind, I can't do Tuesday or Friday prior to looking at the 27th. I didn't want to go that far. I just don't have another on a Tuesday or Friday. I want to get some resolution on this prior to that, but
I'm asking, is that your honor's schedule, Tuesdays and Fridays, or is
no,
that?
it's that in terms of legal aid, when they're here, they have certain days that they're here.
Your honor, this lease expires in June. We keep dragging this out, lease is gonna be up. And I think that's really.
Time that the lease expires October
In
31st.
October, right, so we're getting into the end of June, and then if the court says, okay, you gotta move, and they gotta have time to move, so now we're in July. I know that Mr. Hunter wants to get this resolved.
Attorney Woods, if I had my way, we'd have every document here and I can make my decision today. That's not where
Judge,
we are.
if plaintiff's counsel is requesting that I appear on a non-late day,
You tell me when you can be here. I'll see if I can squeeze it in.
I will, make whatever day you need work.
Let's see what we can find.
Thank you.
All right. It's a little bit sooner, not a whole lot, but it's better. June 22nd at 11.
June 22nd at 11.
Thank you. And the council will provide her contact information. I will forward her a copy of the lease agreement for any documents that I get. And I would ask that she please forward me the documents that she has, so I can review prior to court.
Obviously, that's both parties should do that.
I'm not certain for it. I want that.
I know both people will. What I will ask is this, I'm not telling anyone to do anything, to be clear. I'm not telling you. I am asking because I know this is a family situation. Landlord tenant is very difficult. Anyone. With strangers, it can be very difficult. I think it's even more difficult with family members. I know just by the tone of the last hearing, I know this is something that's been festering between parties. I understand that. The one thing I would demand is that there be, no altercations between parties. And between now and when you come back, I want to hear that someone's calling, harassing someone. I want to hear that someone's coming to someone's door and throwing eggs, whatever on the path. But I think you get my point. I don't want to have any altercations between parties, whether it be verbal, physical, or anything to that effect. When you come back, let's see if we can get some resolutions in the case. However, parties believe that there is some possibility for resolution. My strong suggestion is that you contact the attorneys. I don't know that the parties are able to do that at this point by themselves. Not the signature and paper, but it sounds like this is a hot issue. And I think that probably talking about it just between yourselves might cause more of an issue. So again, I would suggest you have two very good attorneys here. My suggestion is maybe talk with them, see if there's a possibility for resolution that may remove some of the emotion. However, I'm not telling you to resolve it. I'm simply saying that there's a possibility. Two attorneys that can talk, they're both very capable. But if I hear that there's been an issue between now and then, we may have a contempt issue. And then I might have to address it. That I don't want, and you don't. So I'll leave it at that. So we'll conclude for today, we'll come back.
Judge, may I make one final request of the court?
Yes.
That in order to provide a key to at least one key.
Your, if they need a key, I will see that that is facilitated. It's my understanding that they have access. If
Mr. Hunter,
Mr. Hunter.
Mr. Hunter. You got leeway here, sir, that no one else will get. That's only because your reputation, and you know I've known you for years. Please, so when you do that, you disrespect me.
If he does that again, Judge, I will see that, if they don't have that, I will see that they did that. And just again, the items that are there, you now know through the sworn testimony that not having destruction.
All right, so let me make that clear as well. Thank you, Attorney Wood. So let's be clear on this. So it sounds like you provided access to the unit so that you can get to your items. But let me make this clear as well. You are not to destroy, toss out, sell, remove any of Mr. Hunter's items at all. I don't care if they're broken, falling apart. You do not remove anything else from that unit. All right,
Thank you.
we're done for today.
Thank you.
Thank you. All right, council, we'll give you notices if you want those for your respective clients for the next day, but, you know what? Mr. Bogan, Mr. Hunter, why don't you two exit first? Mr. Hunter, I think you can take a second. Exit first, give them about 10 minutes, then Mr. Hunter, I'll let you go, but for now, let them go first, all right? Mr. Rackman?
And if